can you become a citizen, a naturalized US citizen, if you have criminal history? The short answer here, guys, is yes, you can. In fact, you could have a very lengthy criminal history and still become a US citizen. However, there are some things you need to know. The main thing is that there's a good moral character requirement when you're applying for naturalization. So if you're applying for naturalization after being married to a US citizen for 3 years, you need to demonstrate 3 years of good character. Most other people need to demonstrate 5 years of good character on the day that they're submitting their application. So if you're applying today, the government's going to look at the 5 years previous to today's application date to see, are there any acts of bad character during this time? And are you able to submit evidence of good character during this period? So they can consider both things. And the USCIS has put out a policy manual indicating that the lack of criminal history by itself does not automatically create a presumption of good character. So after they issued that policy change, I think it was October 2025, I've made an effort to submit some evidence that you're a good person along with your citizenship application. And previous to October 2025, I never did that unless you had criminal history and we were trying to overcome, your past criminal behavior with evidence of good character so that USCIS favorably exercises their discretion. Okay, so good moral character is the main way in which USCIS can deny a citizenship application. So let me give you an example. I've been mentioning the example of a DUI a lot in my videos because a lot of people get DUIs, and it's a big question that people have because DUI generally, not always, but generally does not render you inadmissible because it's not a crime involving moral turpitude, and it also generally wouldn't make you deportable, but not always. It depends on the specific jurisdiction and the statute under which you were convicted. So let's say you got a DUI 6 years ago, right? You've been a permanent resident for 10 years, and 6 years ago you got a DUI. Can you apply for citizenship now? Probably not. And the reason is because after you got your DUI, you had to do like a 2 or 3 year period of probation, and the probationary period overlapped with the last 5 years of good character. So in that example, you probably would not be eligible for naturalization. USCIS would probably deny your N-400 and say like you'll be eligible on this future date once you've cleared a full 5 years after you've served the consequence of your bad act, of your DUI. Another example, let's say the DUI was 8 years ago and you fully finished the probation sentence such that in the last 5 years, you didn't have to do any probation. Everything was resolved before the last 5 years. In that instance, you probably can apply for citizenship and your N-400 won't be denied solely because of that DUI. It could be denied because of other reasons, but not solely because of that DUI. Let me give another example that has to do with traffic tickets. Let's say you've been a permanent resident for like 20 years and 10 years ago, you were a really bad driver, or you, for whatever reason, you just kept getting tons of traffic tickets where you were getting like 5 traffic tickets a year for several years, right? When you show a pattern of disregard for the law like that, USCIS can try to extend that bad character period. So let me give you an example. So in this example, 10 years ago, you had tons of bad traffic violations. USCIS in this instance could have denied your naturalization if you applied within 5 years of all these traffic violations. But you've gotten your act together and you don't have tons of traffic violations anymore. But in the last year, you got a pretty serious speeding ticket that calls into question whether or not you really learned your lesson from 10 years ago. USCIS can actually extend that bad character into the last year by saying this shows a pattern of disregard, and the pattern is still continuing today, even though there was like a 5-year gap where you got no traffic incidents. This is more of a gray area, but I have seen stuff like this happen, and it is a basis for USCIS to deny naturalization applications, even though in the last 5 years you haven't had anything serious, you just had 1 traffic violation. There is another way that USCIS uses criminal history to deny N-400 applications, and that is by determining that you never properly became a permanent resident to begin with. Here's an example. Let's say you were convicted of a crime involving moral turpitude. For example, some sort of theft offense or assault offense, and you disclosed this on your green card application. So you were convicted of assault, let's just call it assault, in 2019. In 2020, you applied for the green card through marriage or whatever, and you disclosed this assault conviction. The officer determined this wasn't a crime involving moral turpitude, you didn't need a crime waiver, and approved your green card. Now you want to apply for U.S. citizenship. During the citizenship process, USCIS determines that that officer actually made a mistake and that your crime was a crime involving moral turpitude, which would have rendered you inadmissible, which means you did need a crime waiver, but USCIS just made a mistake. And in their decision, they determined that you were never properly admitted for permanent residence because you were inadmissible at the time you became a permanent resident. And therefore, you are now not eligible for U.S. citizenship because one of the requirements for naturalization is to be properly admitted for permanent residence. I've seen this happen many times. And what comes next sometimes is a notice to appear in immigration court, but oftentimes not, especially if you aren't applying for this citizenship within 5 years of becoming a permanent resident. The government generally has 5 years to try to rescind your green card if they issued it in error or they're trying to take it back for some other reason. So it's important to talk to a lawyer before you take these risks. There have been many instances where I've told people, like, look, there's some risk with submitting the citizenship application. It's debatable whether or not you properly became a permanent resident. And if you want to reduce these risks, don't apply for citizenship within 5 years, because if USCIS figures out that they made a mistake by granting you this green card, they have more of an opportunity to rescind it within the first 5 years of you becoming a permanent resident. All right, guys, there is more to naturalizing in crimes. Like, for example, if you have ever been convicted of an aggravated felony and USCIS never realized you have an aggravated felony, you could file your N-400 and easily end up detained and in removal proceedings. So it's important, if you have any criminal history, to speak with a lawyer. But generally speaking, you can have all sorts of criminal convictions and still be eligible for naturalization. And it's not intuitive. You wouldn't know that stealing $1 has way more immigration consequences than a DUI. Like, stuff like this doesn't actually make sense. So when it comes to crimes and immigration, it's really important to do your research, and when necessary, speak with an immigration lawyer who can do that research for you. If you guys need assistance with anything from family-based immigration, removing conditions on your residency, naturalization, or deportation defense, I'm your guy, Pouyan Darian. I'm an immigration attorney handling these cases nationwide. If you want to speak to me, the first step would be to schedule a consultation by clicking the link in the video description below or giving my office a call. Thanks so much for watching, guys, and I'll see you next time for another video.